WA Parliament established this committee, the Joint Select Committee on End-of-Life Choices, and it consisted of 4 members from the lower house and 4 members from the upper house. I was one of the members that was selected to go onto the committee. Now, it started on the 23rd of August 2017, and it ran for 12 months. Now, during the decision that was made by the Parliament to form this committee, the Parliament had to decide on what was going to be the terms of reference. What was it going to ask the committee to do? And you see here, I've just set out for you the terms of reference. So it was asked to inquire into and report on the need for laws in Western Australia to allow citizens to make informed decisions regarding their own end-of-life choices. And in particular, the Parliament said to this committee, we want you to consider these 4 things. You can see them up there at the moment. Now, one of the things that I asked the Parliament to do was to amend these terms of reference before we get the committee to start. If we're going to get them to look into end-of-life choices, which was really code for euthanasia and assisted suicide, shouldn't we get the committee to look into the risks of voluntary euthanasia and assisted suicide? So I moved a motion to amend those terms of reference to include that, just to look into the risks. And the Parliament said no. The government whipped up their members and made sure that they would vote against that amendment. So from the very start, from August of 2017 already, the government did not want the committee to look into the risks of assisted suicide. Now, that was the actual amendment that I had moved, to examine the risks of introducing voluntary euthanasia, including the impact on suicide prevention. And it was interesting that one of the other members who contributed to the debate, a committee member, she said, well, we will be able to have those discussions within the existing terms of reference. Well, I agree we could have done that, but I was saying let's make it explicit. Let's make sure that there's no doubt whatsoever that this committee is going to look into the risks. They still voted against it. And one of the ministers, Minister McTiernan, she says, I urge members not to support this amendment. I mean, why would you be so fearful? What are you so scared of that you wouldn't want the committee to look into the risks of assisted suicide? If you're saying that assisted suicide is going to be a good thing for Western Australia, we need to have this reform according to the government, well, wouldn't you want to look at the risks? I mean, even the most hardened euthanasia supporter accepts that there needs to be safeguards, but they didn't want us to look into that over the 12-month inquiry. So the reason I share that with you is it just gives you a little indication of the context of that committee. When it got formed in August 2017, what was really going on in the Parliament and amongst the parliamentarians. Now, the outcome of the 12-month inquiry, concluded on the 23rd of August 2018, and the committee tabled a report, 229 pages, had 10 annexures, 52 findings and 24 recommendations. Now, when a member of Parliament is on a committee, if they don't agree with something that the committee is doing, they can do their own minority report. But understand this, if you do your own minority report, you're on your own. So if you're on the committee, that My Life, My Choice, which incidentally is a horrible title on something to do with assisted suicide. I mean, are we into suicide prevention or not? But I won't digress. The committee had three full-time staff members working on this report, and that's quite appropriate. That's the Parliament has resourced the committee to do its work. So I don't complain about that. But if you want to do a minority report, you're on your own. They won't even give you a pencil or a pen or a ruler or a piece of paper. You've got to do it yourself. Anyway, so consequently, you can imagine minority reports are rarely tabled, and if they are, there might be a couple of pages. If you saw one for 20 pages, you'd be quite impressed. In Victoria, on the same inquiry that they had, the minority report was 58 pages. So on the same day, on the 23rd of August, I tabled my minority report, 245 pages, plus one annexure, 127 findings and 20 recommendations. Now, I mean, you can imagine the reaction of the MPs because it's unprecedented. And who does that? 245 pages. But the reason that I have done it of that magnitude is to emphasise the point. The risks of assisted suicide are known. We've got the information. The facts are clear. The problem is that the government made sure that the committee would not look into the risks of voluntary euthanasia. So therefore, I've tabled 245 pages worth. Now, Warwick's asked me to take you through that. In fact, he's encouraged you to have a read of it. 245 pages. Come on, Warwick, give them a chance. I'll just highlight a couple of things. You'll be pleased to know, especially those of you standing, I'm not going to go through the whole thing. Now, the chair's report, well, it's called the committee report. Is it the majority report? Look, the truth is it's really the chair's report. So Amber Jade Sanderson, the member for Morley, she basically gets to tell those 3 full-time staff members what goes in the report. It's really the chair's report, and then the other members, they either agree or disagree. They can have some discussion around it, but it's really the chair's report, and unless you vehemently disagree, then you can go and do your own minority report. Now, she says in her foreword to the chair's report, My Life, My Choice, she says, those who fundamentally oppose the introduction of voluntary assisted dying lack rigorous evidence to back up their claims. All right, 245 pages. They will inevitably criticise this process, absolutely. I will absolutely criticise the process because from the very beginning, from day one, I said, let's insert a term of reference which is assess the risks of voluntary euthanasia, and they said no. They didn't want to do that. So of course I'm going to criticise the process, and all I ever say to people is don't take my word for it. Read this report here, the chair's report, the majority report, read my report and come to your own conclusion. Now, was it a one-eyed report from the committee? I can't even be that charitable to say to you that it was a one-eyed report. Now think about it, if you look at something in a one-eyed fashion, if I had a patch on at the moment or something like that, you can still see, you can still look. Okay, the point about it being one-eyed is that you're then doing something in a biased fashion. That's why we talk about things being one-eyed. But the truth is they didn't even look. They never looked into any of the wrongful deaths in any of the other jurisdictions. I've challenged those members to point to me one sentence, one paragraph, one word in their report that deals with the wrongful deaths in the other jurisdictions. They didn't do it. So it wasn't even a one-eyed report. They simply didn't look. And on a more technical point, the Parliament had asked the committee to look into the overlap or the intersection with federal laws. Didn't do it. There's not a paragraph on that either in the majority report. Now quickly moving over to the minority report, some have referred to it with my name. It really doesn't matter one way or the other. Now the background to the report is that of the 8 members, remember I said earlier that there were 4 members from the lower house and 4 members from the upper house who were on this committee. I was the only one of the 8 members who attended every meeting and every hearing during the 12-month inquiry. Now also over that 12-month period of time, now there's 95 Western Australian members of Parliament. I was the only one serving on this committee, the Joint Select Committee on End-of-Life Choices, whilst also serving on the Select Committee on Elder Abuse. So I was the only one of the 95 members on both of those committees at the same time. In fact, I was chairing the other committee as well. I'm one of 2 co-chairs of the Parliamentary Friends of Palliative Care. My other co-chair is the member for Goiran, Labor Member of Parliament, Margaret Quirk, a very good Member of Parliament. And so this is my 10th year in Parliament. Prior to being in Parliament, I was a partner of a law firm. I supervised our civil litigation practice, which included a healthy practice in medical negligence law. So that's the background of which I was providing to the Parliament with the 245-page minority report. Now, the minority report, if you ever get the chance to read it, it's divided into 3 chapters. It's not complicated to understand what the 3 chapters are trying to do. The first chapter is looking at what are the end-of-life choices that are available to Western Australians at the moment. That's what the first chapter is looking to do. The second chapter is saying what are the theoretical risks if we were going to have assisted suicide and so-called voluntary euthanasia in Western Australia. What are the theoretical risks? And the third chapter says what's been the lived experience in those few jurisdictions that have already gone down this path. What can we learn from them? So quickly, with regard to chapter 1, there was a whole range of findings that you'll see in chapter 1, but I've just highlighted 3 for you here. The first is finding 10, that there is an expanding evidence base that has repeatedly confirmed that the appropriate use of sedating or pain-relieving medications does not hasten death, and flowing on from that is recommendation or finding 11, palliative sedation does not hasten death. What does all that mean? It is often misunderstood. It is often misunderstood in the public domain. It is often misunderstood, and it is thought that doctors are already doing euthanasia in some kind of a secretive or a quiet fashion. And you will often hear people say, yes, what they do is that they just give them a bit more morphine. An expanding evidence base has repeatedly confirmed that the appropriate use of sedating or pain-relieving medications does not hasten death. Even Philip Nitschke, there's probably no greater proponent on the planet for assisted suicide or euthanasia than Philip Nitschke. Even he said in evidence to the committee, it's really hard to kill a person with morphine. He said it. So when you hear that in the public space, the reason why people say that, and it'll be particularly people who might have had an experience with an elderly family member, they might have seen that person die, and what will have happened is that they will have seen a person or a doctor or a nurse inject their family member with morphine. They've known that that's going to happen, and shortly thereafter, the next thing that they hear or the next news they get is that the family member's died. So they understandably think injection, death. The nurse or the doctor has upped the morphine and that's caused the death of my loved one. An expanding evidence base has repeatedly confirmed that the appropriate use of sedating or pain-relieving medications does not hasten death. Very important to understand that. And the other finding that I'll quickly highlight is that underdosing and failure to make a specialist referral are problems that lead to unnecessary suffering and distress for patients and loved ones. Why is it that 80% of Western Australians keep saying, oh, I think I'd support voluntary euthanasia? Why do they do that? For some of them, they have seen their loved ones die in a most unsatisfactory fashion. Well, why has that happened? It's happened because there's been underdosing or there's been a failure to make a referral to a specialist. That's why people in Western Australia still die in pain when that need not happen. So the important takeaway from chapter 1 is that we can alleviate suffering without killing people. And if you ever get the opportunity, and maybe Warwick, this could be a thing that we look at doing on another occasion, I'd very much encourage people to have a look at the movie Fatal Flaws. Runs for about just under 60 minutes, and Alex Schadenberger is the Executive Director of and International Chair of the Euthanasia Prevention Coalition. That's a quote from him out of the documentary. We can alleviate suffering without killing people. Now, moving ahead to chapter 2, remember I said chapter 1 is setting out what are the current choices for Western Australians at end of life. The second chapter is looking at what are the theoretical risks. If you're going to implement voluntary euthanasia and assisted suicide, what are those risks that we need to consider? Now, the first thing I want to touch on is voluntary and informed consent. You see, what will happen in this debate, when you engage with people, the very first thing that they will say to you is that, yes, we hear what you've got to say, Nick, but it's voluntary. No one has to do this. Okay, well, let's test that. voluntary and informed consent. The truth of the matter is that steering is the elephant in the room. What's this business about steering? Well, how easy is it to steer a person who is in a vulnerable state to make certain decisions that you want them to make and not necessarily what they want to make? We've got an elder abuse problem in Western Australia, and one of the most common forms of elder abuse is psychological and emotional elder abuse. And that's because of steering. People taking advantage of the elderly in particular and steering them into a particular direction, getting them to sign documents that they want signed. Maybe it's a power of attorney, maybe it's a will, maybe it's because a person's got what we call inheritance impatience syndrome. Now, steering is a big problem. Don't forget that. When it comes to voluntary and informed consent, sure, any one of us could make a case for an ultra confident individual saying, I absolutely want to kill myself, I am of sound mind, I've been given all of the information. Yes, those people probably do exist. They are not the ones we're worried about. The ones we're worried about are the ones who are going to be taken advantage of because of steering, the ones who are already subject to elder abuse, which we know is prevalent in Western Australia. The second thing that I want to talk to you about in terms of these theoretical risks if you're going to bring in euthanasia, one is that it's not really going to be voluntary for some people because they're going to have been steered into the decision. But keep this in mind. The most ardent of euthanasia proponents will say, yes, but there needs to be safeguards. I can't tell you how many members of Parliament at the moment in our WA Parliament who are going to vote for this at some point later this year say, look, I agree, I think we should have euthanasia, but there'd have to be safeguards. Of course there'd have to be safeguards, they say. Well, remember, a safeguard is only as good as the doctor who's enforcing it. As soon as the doctor makes a mistake, the safeguard is worthless. How easy is it for a doctor to make a mistake? Remember I said earlier that my law practice was dealing with medical negligence law. So every one of those cases was a mistake. If the doctor gets the diagnosis wrong, the prognosis wrong, what happens then? Now, I want you to think for a moment about the issue of capital punishment. Why is it that we do not have capital punishment in Western Australia? We haven't had it for decades. I think it's something more than 30 years now that we haven't had capital punishment in Western Australia. Why don't we have that in our state? And indeed, why do we not have it in any of the jurisdictions in Australia? It doesn't happen in our federation. It did once upon a time, we don't have it anymore. Why? Well, the reason why most people will be opposed to capital punishment, including me, is because of the risk of a wrongful death. Because we're concerned not about the majority of the guilty criminals, we are concerned about the one criminal who has been found guilty but is actually innocent, and that they will lose their life wrongfully as a result of that. That's why we don't have have capital punishment in Western Australia and in our nation. Now think for a moment about the safeguards. Remember, this whole debate's about safeguards. Think about the safeguards that we have in our criminal justice system. In order for a person to be subjected to capital punishment were it to exist in our state, first of all, you'd need to have a complaint. Now, once you've had a complaint, the complainant doesn't do the investigation. An independent body, which is the Western Australian Police Force, they do the investigation. Now, during the course of the investigation, they can summon the suspect in for an interview. I use the word summon loosely for those legal practitioners here. They can call the person in for an interview. But you know, during the course of that interview, the person doesn't have to say anything. They have to reveal their name, they have to reveal their address, and that's it. They don't have to say anything else. Why is that? That's a safeguard for that particular person so they don't self-incriminate themselves. But you know, in Western Australia, we're super generous. That person will be entitled to have a lawyer present to make sure that they don't make any mistakes during the course of that interview. And we're so generous, we will fund them through the legal aid process to make sure that they have that lawyer present in the room. Now, after all of that, if the police, the independent body that's investigated this issue, if after all of that, the police say, yes, we're still confident that we got a case here, they're going to lay charges. Now, is it the police that prosecute the charges? Not for these type of cases. No way. There's an independent body. It's the Director of Public Prosecutions. And she and her team, they are the ones who then independently go and prosecute that case in the courts. And they reconsider the evidence and they decide, well, hang on, have the police done a good job in this one or not? If not, we're going to withdraw the charges. So there's another check and balance in place. Now, when they're prosecuting that case, what else happens? The accused is entitled to a lawyer again. And for the duration of the trial, in our very generous system in Western Australia, we will make sure your lawyer's there. We will even fund you through the legal aid process. Now, who makes the decision? Is it the prosecutor, the person who brought the case to court? No way. There's a jury that gets selected who decides whether you're guilty or not. And you know, when the jury process takes place, you can even object. You don't even have to provide a reason. No, don't like the look of that person, they're not going to be on the jury. Another safeguard that's in place. Now, throughout the whole trial, we then have an expert lawyer, they're called a judge, and they are overseeing this whole process to make sure that under no circumstances is there going to be any mistake made. We're going to make sure that this person gets a fair trial. At the end of all that process, imagine the person's found guilty. You're pretty confident about the conviction after all of those safeguards, right? But in Western Australia, we give you the right to appeal. We say that, you know, you can appeal that decision and get another group of judges, not the same judge, mind you, a different group of judges to consider that. And throughout that appeal, we'll make sure that you're legally represented as well. And we, the taxpayer, we will fund that. We'll make sure through legal aid that you're well protected over that, because we want to make sure there's a lot of safeguards in place. And after all of that, you could still go to the High Court if you wanted to. Now, despite all of those safeguards, all of those checks and balances, we as a community say no to capital punishment. That's too risky, that there's the possibility of one wrongful death, that one person will die when they're actually innocent. And now the government wants to tell us that having 2 doctors sign off on an assisted suicide request is a safeguard. You can understand why I don't feel very safe with the government's regime. In elder abuse cases, remember I was talking about earlier how we've got a problem with elder abuse? People are taken advantage of because of steering. Redress, this is finding 30, redress can be difficult in some elder abuse cases when the best witness lacks capacity to give evidence. So the evidence that was provided to the committee, they said, look, when we're trying to tackle these cases, these people are taking advantage of these elderly people. It's really hard because the person who's going to be our best witness, they're really not in a very good position to give evidence because of capacity issues and the like. Now that's when the person's alive. How do you provide redress when your best witness is dead? So that's the fundamental problem, and why I've always said that it is impossible to protect people against involuntary euthanasia if you're going to allow a so-called voluntary euthanasia regime to exist. So the key takeaway there is that from a theoretical perspective, casualties are guaranteed if you're going to have euthanasia. Now, quickly I'll move to, and you'll be pleased, especially those guys standing, this is the final chapter. Lessons from other jurisdictions. Now, very quickly, because I could speak for hours on this one. Usually what happens is that people will say, look, the guys in Europe, they've had euthanasia for a very long time, and that's true, they have. So we should follow follow them because, you know, it's been very safe there. And normally we start with the Netherlands, and so I'll then say to them, well, you realise in Netherlands that incrementally the practice of the law has changed there, so that now those who are mentally ill subjected to the euthanasia regime. Oh, they say, well, hang on, we're not talking about that in WA. Oh, don't worry about Netherlands. What about Belgium? And I say, well, the problem with Belgium, you know, they changed the law there. Originally it was only for adults, and then suddenly they said, well, we better allow it for children as well. Oh, no, we don't want that in Western Australia. No, let's not worry about Belgium. Oh, what about Switzerland? Well, they've got no rules. Remember Professor David Goodall from Western Australia? He was 104, I think it was. And he was tired of life. And so he went to Switzerland. It's a very, very, very sad case. And the Western Australian community, including the Premier, I might add, at this stage, said, oh, we wish you the very best. And there was even a GoFundMe page, get this, to make sure that his ticket there was upgraded from economy class to business class. Now, why would people donate to that GoFundMe page? They would do so out of a sense of compassion. The people who donated, I'm sure, would have said, we feel very sorry for this man and we want to try and do something for him. But you know what they could have done? They could have taken him out for a meal. That money that they had spent, let's say it was a $100 donation or $200 a donation, why not go and take the guy out for a meal and learn from a guy who's got 104 years of life experience? Do you think we might learn something from this guy? He was tired of life because one of the universities has said, look, you're too old and so you really shouldn't be here anymore. Well, he would feel hopeless. He doesn't feel valued. As a community, we should be valuing our elderly, not saying, look, you're past your expiry date. So Switzerland had no rules. Okay, well, we won't do that in Western Australia. We've got to have some rules. We've got to have safeguards, right? So well, let's go to Northern America. Oregon, it's been in place for 20 years. Must be safe there. Well, you realise they've had problems with complications, with the distribution of the drugs. You're supposed to only access it in Oregon if you've got 6 months to live. And people have had the drug prescribed and then taken it 2 years after the event. So clearly there's a prognosis problem with the medical fraternity in Oregon, to say nothing about doctor shopping in Oregon. Basically, if you don't get the decision that you want from one doctor in Oregon, you just keep shopping around until eventually you get the doctor that agrees to give you the pills. So then I move to the Northern Territory. I say to them, you realise that we have already experienced euthanasia and assisted suicide in Australia, and it was in the Northern Territory, and most people forget about it. It was in 1996 and it only lasted a few months. So what can we learn from the Northern Territory experience? Because if you talk about the other jurisdictions, usually the proponent will eventually say, oh, but that's the Americans, that's the Dutch, that's the Belgians, we're not like them, we wouldn't do that. Yeah, of course. But would we do the same thing as what's happened in the Northern Territory? When assisted suicide was legal in the Northern Territory, one patient was euthanased even though he was jaundiced and suffering from a bowel obstruction and not advised of the palliative care and medical treatment available. The psychiatric certification that was part of the law there you needed to have, because that was going to be a safeguard, in that case consisted of a 20-minute consultation paid for by Dr. Philip Nishke on the day the assisted suicide was scheduled. I feel so safe when I hear about that. This is no longer a theoretical risk, theoretical discussion. That's the lived experience in our own country when we've had assisted suicide. Finding 72, doctor shopping took place when assisted suicide was legal in the Northern Territory. There was another case where a person had mycosis fungoides. It's a blood disorder or condition which affects the skin. It's a serious condition, and this person wanted euthanasia. And under the Northern Territory regime, you needed to have 2 doctors to agree. Well, the first doctor was, of course, Dr. Nishke. He needed a second doctor. And remember that the safeguard in the Northern Territory regime was that the doctor needs to have some experience or qualification in the disease or the condition that's the problem. Well, he couldn't find one. The local oncologist and the dermatologist said, sorry, we're not signing off on this. This person's not terminal. So the second doctor that Dr. Nishke finds is an orthopaedic surgeon. Now, I love orthopaedic surgeons when I've got a problem with my back, but an orthopaedic surgeon has got absolutely nothing to do with mycosis fungoides, and that was the That was the so-called safeguard in the Northern Territory. Again, not theoretical risk. This is a person who's died as a result of that regime, and as it so happens, had a history of depression, I might add. Finding 73, when assisted suicide was legal in the Northern Territory, one patient who had received counselling and antidepressant medication for several years was euthanased after a psychiatrist from another state certified that no treatable clinical depression was present, even though that neither the patient's adult sons nor the members of the community palliative care team who were caring for him were told he would be assessed for assisted suicide. How safe we must feel when we find out that that's how assisted suicide works in our own country during the brief time that we experimented with this. So what did the experts have to say during the course of the inquiry? Amanda Forrester, who's she? She's the Director of Public Prosecutions in Western Australia. She said this on the 27th of February last year. Yep, nearly exactly a year ago. There is only one person left usually to tell what happened, and that is the person who's under investigation. That is the real problem. At the end of the day, it is one person say so. The patient, of course, is deceased. What did Professor David Kassane say to the committee? Well, he didn't say anything to the committee because the committee never asked him for his opinion. There's no bigger expert in this area in Australia than Professor David Kassane. He was made a companion of the Order of Australia in January 2018 for his contribution to the field of psycho-oncology and palliative medicine as an educator, researcher, author and clinician, but he was also the academic that reviewed the 7 deaths in Darwin when we had the euthanasia for a short period of time in the Northern Territory. He was the lead academic that looked into it. Committee never talked to him. You know who they talked to with regard to the Northern Territory legislation? Philip Nishke. And also the Chief Minister, who I'm going to get to in a moment, the Chief Minister of the Northern Territory, who brought in the legislation, who still to this day is a big fan. But we wouldn't want to talk to Professor David Kassane. So what has he had to say about this? Well, the clinical experience observed during the brief life of the Roti Act, that's the legislation from the Northern Territory, could be regarded as an experiment in which the legislation that supported the practice of euthanasia can be examined for its effectiveness. This clinical experience demonstrated the inadequacies of provisions of the Roti Act and suggested that the vulnerable cannot be safely protected by such legislation. Marshall Perrin, this is the Chief Minister that I was talking about before. Now remember, he was the guy who brought the legislation in. He was the guy who brought the legislation in. To this day, he's still a supporter of it. When I asked him a question during the committee hearings, remember, I was the only one who was there for all the meetings and all the hearings. At one of them, he was present, and I asked him a question about redress. And his answer was, and that's why I put it up here, because it's absolutely accurate and absolutely true what he said, because he had nowhere to hide. There is no redress for family or friends in the event that a death was hastened and one or more of the eligibility requirements was not met. Obviously, one cannot be brought back from the dead. Precisely why we don't have capital punishment. And the last person who I will quote from is Dr. Michael Gannon. Now, at the time, in May 2018, he was the president of the Australian Medical Association, and he says this: I have serious concerns about a community where we make arbitrary decisions about whose life is valuable enough to continue and whose should be ended under the law. A society should aspire to look after people who are struggling and to make sure that their lives are worth living. We should aspire to even better end-of-life care. We should aspire to better palliative care. So if, like me, you're passionate about this particular issue, if you're a religious person, you should pray about it. Whether you're religious or not, you should visit your Member of Parliament and express your point of view. I think in particular that it is worthwhile writing to your local MLA. So everybody in this room has got their local Member of Parliament. You've all got one MLA and you've all got 6 MLCs. If you're not sure about that, I'm sure that Warwick can get you that information. I think it's worthwhile you expressing your opinion to them. If you're inclined to go and meet with them, it's even better. And if you're quite understandable you don't want to go alone to meet with an MP. It's actually better if you go in as a group of 2 or 3 anyway and express your concerns. And the simple concern is that there's going to be casualties. We're concerned that steering already takes place. We've got an elder abuse problem. We know that palliative care can be very effective. We just need to make sure that people have access to palliative care. And of course, continue to ask questions of those who are supportive of euthanasia, so that they might start to think about these things, including the lived experience in the Northern Territory. So that's it from me. Thank you very much for your attention. As I said at the outset, I apologise I'm not in tip-top shape today, but hopefully you've got at least a bit of an overview of some of the concerns that exist if we were to go down this path in Western Australia and legalise assisted suicide. There would be casualties guaranteed. It's not just my view. Clearly that's been the experience in other jurisdictions. Thanks so much for having me here today.